Hey, so this is a addendum to the recent video. In fact, it was earlier today because I was in hearings today, and the particular hearing where there were a few hours out now, and I have no more hearings today. But it was the one where I was explaining, oh my gosh, don't freak out if your technology goes down and you have an MS Teams hearing scheduled, and suddenly you are like, my internet's not working. I go into what happened in my situation this morning. And it's really supposed to be a be calm, it'll work out. Just take the necessary steps to communicate with your OHO. So that was all good and dandy. And then I still had time to kill before the hearing because the judge's office was really, really belated due to prior hearings that were wrapping up a little late. And I did a little add-on to that discussing all the, how the different kinds of video hearings you can have between video, phone, in person, the pros, the cons, and how we would handle them. So this is just after that. We eventually did get, the next thing I know, I'm hearing and I was working while I was waiting, because I was waiting, I want to say an hour and 45 minutes or something like that. We were late. And I had communicated with the client saying, just hang tight, they're running really late. Then the office came on and said, and this was through the video, but we're not recorded or anything, this is off the record. So they didn't have to call me. I'm like in the waiting room. Like when people Zoom with me, they're in the waiting room till I click them in, right? So they said, there's some serious tech issues. We don't know what's going on. Well, the judge came in and she too was waiting. So it was just me and her, and she and I, and we were talking about, she was explaining to me some of what she thinks is going on. There's so many different parts to it. They have, every hearing is audio taped, not videotaped, audio taped. So phone and video hearings are audio taped. Oops, hold on. I just got to take this call real quick. Okay. So yeah, so they were having, and I forget exactly where I left off. They were having an issue with the recording software that is used to record the audio, which is 100% necessary for any hearing, because that is what an appellate panel or anything appellate is going to be reviewing as part of the record. So if they don't know exactly what was said at hearing, there's no way to know whether an ALJ did everything he or she was supposed to do at the hearing. Okay, so the audio hearing, you cannot have a hearing that will go forward if you don't have the recording of same. So in this case, that had gone all awry apparently, and there was some other issues, but so it was a I want to say an hour and 45 minutes or something like that delay, and then we got to have initiate our hearing, and that was all great. And then when it was time, how with the ALJ hearings, I've described this before, after the testimony from the claimant regarding any prior work, and then their activities of daily living and their symptoms and their functioning and their limitations come out in terms of discussing how it affects their day-to-day life, the ALJ generally offers up hypothetical situations, hypothetical individuals with a certain amount of RFC, residual functional capacity, to the vocational expert to find out if there would be any job that hypothetical person could do. And there could be multiple hypothetical people with differing limitations inquired of. Well, the vocational expert, who was, I could see they're usually there on the phone. I could see the phone number in a little circle that would represent that person, was present. But when the judge said, "Hey, vocational expert, so let's start with you, let's go inquire to you," and there was no response. So they're like, hello, Mrs. So-and-so, are you there? Then the court reporter or the clerk, I'm not sure which reference would be appropriate, but either one, she's like, "Jane, are you there?" And there was, and she could tell that the person it appeared to be online and did not appear necessarily, I guess, to be muted, because I think they could see that. and there was just no response. So after a couple of minutes, and I felt so bad for the judge because she's been having one issue or another the whole morning on all of her cases. I mean, this is just one case for us. Although it's the claimant's whole case. So for the claimant, it's got to be uber terrible. And for the judge, second uber terrible. And for me, roll with the punches. But so ultimately, we halted the hearing, but all the testimony had been given. And we are going to do the vocational part separately on the record, of course, and probably with a phone hearing for that. Client doesn't have to be there because there's no more testimony to be given. He just won't witness it, but it will be in the audio recording if we ever wanted to hear it. And so the judge will ask those vocational questions at that time. I will be there to cross-examine. The alternative, by the way, to doing it that way when it's post first hearing is a lot of times they'll do it by interrogatory, written questions from the judge to the vocational expert. So just like in physical person, the judge would give in writing, here is a person with this, and this limitation. Are there any jobs they could do? Can they do their old jobs? In this case, there is no prior work. It's a young person or older or other work. And it's very cumbersome because once that VE gives a written reply back as to whether under those situations, whether there are, if I don't agree with the RFC given, and I can suggest other limitations that I think are evident in the hearing file, in the medical file, I'm going to need to cross-examine it. Can you imagine doing that on paper, back and forth with everyone gets a month? I mean, this would be a 10-year long process feasibly. So when the judge offered that we could do it by phone, waive the claimant appearance, doesn't have to be there, or else that would take even more. And I'm waiving the 75-day notice requirement. So literally they could call me, they could say, hey, can you do this tomorrow? And I'd be like, yeah, let's do it. That's what we're going to do. So we can get this done. Yeah, because in writing, going back and forth, can you imagine? I mean, it would just take forever because my questions are going to stem on what the RFC is and what the VE's response is completely. During the hearings, we're literally listening and writing, recording down what we need, what we hear that's relevant, that we're going to have a question that we're going to want to dig into more. And it's very fast on your feet when you're in the middle of a hearing doing it. But on paper, oh my gosh, it would take, I can't even imagine how long it would take, unless the response is wonderful. If that RFC is on point and it shows that there are no jobs and the VE says there's no jobs, then end of story for sure. But you can't go and assume that. So I was grateful for the opportunity to put it back on a verbal hearing, over the phone to finish it up. So anyway, like I said, you got to roll with the punches, guys. They can change at any step at any moment of the day. And as long as you kind of stay calm and, rational and communicate, I think is the biggest thing. Communicate with your OHO, your ALJ's office. All these things that go crazy they'll be worked out. They will be worked out one way or the other. Okay. So anyway, that's my follow-up to that hysterical earlier share that I did today when we were pending hearing. I'll talk to you later. Bye now.